Hello everyone, welcome to Abinisio. In today's session, we are going to discuss about a problematic question which was asked in 2021's procedural paper. Before starting the session, I would like to wish you and your family a joyous and prosperous Durgashtami. On the eve of this Durgashtami, we are thrilled and pleased to announce our new upcoming judicial batch, which is going to commence from 6th of November. The details of the batch is given here. In this package, the classes for this batch will be imparted in both online and offline mode. You can join the batch as per your preferred time slot. The batch will be conducted in the morning as well as the evening sessions. Classes will be conducted by our experienced faculties who had served previously the judiciary for more than 5 to 30 years. There will be daily question and answer discussion sessions. Apart from that, daily answer writing tips and techniques will be given or will be imparted to our students. Apart from that, there will be weekly assessments on the basis of regular tests conducted by our experienced faculties. And the timeline is here. The morning batch, the classes will be from 7 a.m. to 9:30 a.m. For the evening batch, it will be from 7 p.m. to 9:30 p.m. The course duration will be of 10 months and it will cover all the law subjects which are imperative for our judicial preparation. It also includes the special English paper. Here are a few admission details. Our offline center is situated at CDS Sector 2, Cuttack, near Ashwini Nursing School. The admission starts from 23rd of October 2023 and the classes will commence from 6th November 2023. Here are the few contact details. You can contact here for more information regarding the upcoming judiciary batch. You can call on to this number or mail us your details or queries to this mail address. So without any delay, let's start our today's discussion. Now our today's discussion is going to be regarding section 41 of CRPC. So there is a question which is asked in 2021 OJS examination, question number 2B. Here is the question. A police officer has come to know that certain persons sitting in a house equipped with arms are planning to commit a dacoity. The police officer approaches the house and arrests all the persons without getting any order from the magistrate and without any warrant. So examine the validity of the arrest. So who can frame the issues and tell me the necessary legal provisions associated with this case law, with this particular question? Krishna madam?
Sir,
What will be the issue? Yes.
whether the act amounts to criminal conspiracy or not, then under criminal conspiracy, whether the arrest is justified without getting the warrant from magistrate or not.
First one is your conspiracy. Second one is about
Arrest without warrant, whether that arrest is
arrest
valid or
without warrant.
not.
Okay, then why do you think conspiracy can be brought here? Okay, anyone else? What legal provisions should we discuss here? Mamta madam.
Sir, here issue may be planning to commit a dokaiti. That that may be issue,
Yes.
and second one is arrest.
And legal provisions we need to discuss? Which legal
Sir, it
provisions?
is section 151 I think in CRPC, planning to commit a docaity.
151 CRPC କଣ କହୁଛି? Okay, anyone else wants to substantiate this answer? Madam?
Sir, it might be a cognizable offense committed or suspicion exists will be there, and which might be a cognizable offense, and so because of that he can be arrested without warrant because of any of the reasonable or credible information as per section 41B.
So you are telling me that there might be a cognizable offense which is going to happen. That's what you want to say here.
Sir, certain persons sitting in a house equipped with arms. So there might be there is a possibility of any cognizable offense that.
Okay, you are putting emphasis upon possibility.
Yes.
Is it
Sir,
so?
as section 151 says, arrest to prevent the commission of cognizable offences.
Yes. So it will be preventive.
It will be preventive under 151 or 41.
It's because there is planning to commit a docaity, so it may be a preventive order.
So the act is justified under 151 CRPC. That's what you want to say.
So 391 mentions that when more than five or more person
What
attempt to 391 IPC.
Okay, 391 IPC. What does it say?
It's the definition of docaity when five or more person conjointly commit to do any or attempt to commit a robbery, then all are maybe arrested. Raiding also.
Okay.
So it may be all are arrested because they are also aiding to them. So this provision may be attempted, and also 393 is the uh, punishment for that. Regarding to docaity, so there is a provision that 41 be that whenever any person is trying to make any docaity, so they may be arrested to prevent any docaity.
So your answer is 391. There is a thin line of difference. It is attempt to commit a robbery, but it talks
Yes.
about the preparation. Question is about preparation. Is there any difference between preparation and attempt?
Okay, so they're planning to commit a docaity means we can put them in criminal conspiracy also
They
because
are
they're
planning.
planning.
They can also drop their planning. They have the chance to repent, so they can also drop their planning. Is the preparation can be punishable in general?
No, sir. No, sir.
No, the question is about preparation. How can you invoke this section provision of section 391? 391 is about attempt.
So they
Here the
also
question
possess
was,
equipped with arms.
yes, mind those points which you are bringing here. You are correct while bringing these points. Preparation, arms, equipped with arms, we'll deal with that later. But prima facie, just tell me that the question is very specific about preparation. So ଇସ୍ୟୁରେ ବି ଆପଣମାନଙ୍କୁ ସେ କଥା ସବୁ ଲେଖାର ଅଛି. Whether this particular offense of IPC is made out or not. Preparation ଅଛି କି ନାହିଁ? Being equipped with armed weapon, will it bring some kind of culpability or not? These are the issues. First of all, 391 is not the relevant provision. 399 is the relevant provision. 399 and section 402 of IPC are the relevant provisions. 399 କଣ କହୁଛି ନା making preparation to commit ଡକାୟତି. There is the only case where preparation itself is punishable. 122 is there, 126 is there, all those provisions where preparations are made punishable. One.
Okay.
So 10 marks question ଏତେ ଲେନଦେନ କରିବା ଦରକାର ନାହିଁ ଯେତିକି required provisions required portion we will try to cover that. So section 399 and section 402 of IPC are relevant provisions here. 399 IPC କଣ କହୁଛି?
Making preparation to commit
Yes,
offense.
to commit डकैती. 399 being a specific offense and which is cognizable in nature, and it is an offense which is more which can be punished with rigorous imprisonment for a term which may extend to 10 years. So by virtue of this, the arrest of the police officer is justified. 399. Then section 402 is also a cognizable offense where the prescribed punishment is 7 years or more. Yes, which may extend to 7 years.
So तो এই
I
केस में
just
कोटा अटक को सेक्शन टा
both in cases both the sections are applicable.
तो सर पनिशमेंट
399
पनिशमेंट 7 year ना 10 year होबो.
have you heard about this the scheme of punishment which is either concurrent or subsequent nature जो सब अच्छी punishment in what is a concurrent punishment?
One
Concurrent and
after the
The
other.
consecutive.
punishments shall run
Simultaneously.
simultaneously. All the punishments shall run simultaneously.
Yes,
Simultaneously all the
concurrently.
punishment, but not more than 14 years.
That's a different thing depending upon the power of the magistrate or the judge. So ସେଠି ଯୋଉ concurrent ଆଉ consecutive sentences ଗୁରା ଅଛି ସେଇ ହିସାବରେ punishment ଦିଆଯାଏ. either 399 ରେ କିଛି punishment ଦିଆହବ ନହେଲେ 400 ରେ କିଛି punishment ଦିଆହବ. ସେତିକି punishment ସେଠି judgment ରେ ଲେଖା ହବ ଯେ these punishments shall run concurrently or consecutively. ଯଦି concurrent ହେଲା ସେମାନେ simultaneously run କରିବ, ଯଦି consecutive ହେଲା one after another run କରିବ. Okay, 399 ପାଇଁ ମନେକର 2 years, 402 ପାଇଁ ମନେକର 1 year, and it will be mentioned that it will run concurrently or it will run consecutively. ଯଦି consecutive ହେଲା first 399 ପାଇଁ 2 ବର୍ଷ ରହିବ, ତାପରେ 402 ପାଇଁ 1 ବର୍ଷ ରହିବ. That is a different aspect. But here our point is that ki which legal provisions need to be attracted. 399 being a specific cognizable offense, though at the stage of preparation it is punishable and the arrest of these accused is justified. So ଏତିକି aspect ଆମକୁ touch କରିବାର ଅଛି. First କଣ issues you can see here, ଏତିକି issue ଲେଖିଲା ପରେ legal provision କଣ ନା section 41 କୁ mention କରିବା ପାଇଁ ପଡିବ, section 151 କୁ mention କରିବା ପାଇଁ ପଡିବ, ତାଙ୍କ ଦୁଇଟା ଭିତରେ distinction ବି draw କରିବା ପାଇଁ ପଡିବ. section 41 ର ingredients ସବୁ କଣ କଣ, why it cannot be section 151, that also has to be written, and section 399 and 402 of IPC has to be specifically mentioned, and there is a thin line of difference between section 399 and section 402. There is a reported landmark judgment of Odisha High Court itself which distinguished section 399 from section 402 of IPC. That also has to be written, and case laws ଯାହା ବି ସବୁ ଅଛି ଲେଖିବା ପାଇଁ ପଡିବ. ଆଉ ଯଦି stages of offense ଆପଣ introduce କରିପାରିବେ, ଖାଲି ଏତିକି ଲେଖିବା ପାଇଁ mention କରିବା ପାଇଁ ଯେ whether preparation can amount to an offense or not. This much aspect. ସେଟା ଟେଷ୍ଟ ଦେଖେଇବେନି ଯେ locus penitentiary test, equivocality test, ଯାହା ବି ସବୁ ଟେଷ୍ଟ ଅଛି ପ୍ରିପାରେସନ ଆଉ ଆଟେମ୍ପ୍ଟ କୁ ଡିଷ୍ଟିଂଗୁଇଶ କରିବା ପାଇଁ ସେମିତି କିଛି ଟେଷ୍ଟ ଲେଖିବା କିଛି ଦରକାର ନାହିଁ. ଖାଲି ଏତିକି ଲେଖିବେ ଯେ whether preparation can amount to an offense or not. So ଏତିକି ଜିନିଷ ମେନସନ କରିବାର ଅଛି ଆନ୍ସରରେ. ତ ସେକ୍ସନ 41 ଫର୍ଷ୍ଟ କଣ କହୁଛି, ଇନଗ୍ରେଡିଏଣ୍ଟ ସବୁ you all are aware of it, ଯେ cognizable offense ହେଇଥିବା ଦରକାର, ଇନଫର୍ମେସନ ଗୋଟେ କ୍ରେଡିବଲ ସୋର୍ସ ଅଫ ଇନଫର୍ମେସନ ଆସିଥିବା ଦରକାର, ଆଉ arresting officer ର ଗୋଟେ reason to believe ଥିବା ଦରକାର ଯେ yes such kind of offense might have been committed. Then proclaimed offender, stolen property ଯଦି କାହାର possession ରେ ଅଛି, କିମ୍ବା obstructing a police officer to perform his duty or who is a deserter in case of extradition or released convict or requisition, ଯଦି under section 42 one is concealing his identity, then also he can be arrested. So information part टाକୁ जोटा कि बहुत मिस कर दियंती ता गोटे मन रखिबे information जदी आछि if the offense is punishable with less than 7 years and if the offense is punishable more than 7 years. If more than 7 years just there has to be a reason to believe that such offenses might have been committed, then such person can be arrested. 7 ବର୍ଷରୁ କମ offenses ଅଛି like in the honest more guideline or the checklist କଣ ରଖିବାର ଅଛି ଏଠି ଦିଟା aspect ରଖିବାର ଅଛି. One is reason to believe ଥିବାର ଅଛି ଆଉ ଗୋଟେ necessary for these points 5p मन रखिबे गोटे to for the proper investigation of the case the arrest is necessary, to prevent the tampering of evidences arrest is necessary, or to prevent from making inducements the arrest is necessary, and lastly ensuring the presence in the court arrest is necessary. ଏତିକି ପାଞ୍ଚଟା checklist को justify classify करिवे यदि ପାଞ୍ଚଟା checklist satisfy करूची then he can be such persons can be arrested. So section 41 में एतिकी ingredient लिखि देबे गोटे पेज summarize कर देगी. So I will share it in the group. Then next होची preparation to commit a crime जोटा कहले आपण इंट्रोडक्शन दबार अछि स्टेजेस ऑफ क्राइम रे जे प्रिपरेशन अटेम्प्ट फर्स्ट होची कोन और तो फर्स्ट स्टेज ऑफ ए क्राइम और ऑफेंस. First of all, who can tell me what are the stages of an offense? Intention. That is also not punishable. Then the preparation in general is not punishable, but in certain cases preparations are also punishable. Section 39 is one of them. Section 399 is one of them. So all these things you need to mention. Then you will proceed to section 41A, 41 subsection 1A. सेठी आपनको पर्टिकुलरली लिखिबार अछि यदि पुलिस ऑफिसर प्रेजेंस रे किछु कॉग्निजेबल ऑफेंस होउची देन द पर्सन कैन बी अरेस्टेड विदाउट वारंट. So section 399 is a cognizable offense. This is as this is in nature of cognizable offense, such persons can be arrested. Okay. Next होची arrest without warrant by police officer. There are two such provisions. One is section 41, another one is section 151. All these provisions you need to mention. Then section 151. Arrest to prevent, these are the preventive actions taken by the police officer. जदि किसी पुलिस ऑफिसर को लागुची जे गोटे डिजाइन होउची जोटा की cognizable offense commit करी पारे, like you pointed out there might have been a case where a cognizable offense is going to committed by some kinds of persons, then to prevent such design the police officer can arrest the person under section 151. 151.2 कहूची जे no persons can be detained beyond 24 hours. Same in the case of section 57 of CRPC and article 22 of constitution. Then there is a case law to this effect ki back to the facts of the case. Sridhar Query versus State of Bihar. The Supreme Court has held that the mere fact that the accused was arrested on the spot and some articles including firearms were recovered from his possession would not be sufficient to prove the charge that they had assembled for making preparation of commission of डकैती. This was also about section 399 and 402. The Supreme Court कहले जे जदि place of arrest रे accused मान को arrest करा जाइछि place of commission of the offense रे offense commit हेई नाही किंतु तांको पोजीशन किछि firearms recover करा जाइछि, that is not sufficient to convict them under section 399.
सर एक केस रे 120B रे 120B रे ताले पनिश करी होबो.
Definitely, if it is established that they are planning to commit an offense, this is a pure question of fact. The facts in the thibo, yes, these are the pure question of facts. The facts in the thibo, then evidence regarding thibo, then also we can convict him. Why not? Because a mere agreement to commit an offense is per se punishable. ଯଦି ଖାଲି agreement ବି କରୁଛନ୍ତି ଯେ ଆମେ offense ଟା କରିବା ବୋଲି act ଟା କରିବା ବୋଲି, then this is punishable and overtax is not necessary at all. Then presumption of innocence. If there are two contrary views and one is adverse to the accused and one is conducive to the accused, then the favorable one will be taken. The burden lies upon the prosecution to prove this case beyond reasonable doubt. So this can only be discharged with a proper or solid or lucid evidence, and the court will always take the view which favors the accused. Now, distinction between 399 and 402. Jagannath Manduri versus State of Odisha. This judgment is being used by various high courts while disposing of their cases. This is a very important landmark judgment. So 399 or 402 ଭିତରେ ଯଦି distinction ଆସେ, so you have to mention this case law. ଆଉଥରେ କହିଦେଉଛି ଜଗନ୍ନାଥ ମଣ୍ଡୁରୀ versus State of Odisha. Then, though the offense falling under section 402 of IPC and offense falling under section 399 would probably involve almost similar ingredients. ଯଦି 399 କୁ ଦେଖିବେ 402 କୁ ଦେଖିବେ, you cannot distinguish between them. There is a thin line of difference. 402 ରେ କହୁଛି ଯେ mere assembly without any preparation is enough to attract the offense of 402. But 399 କହୁଛି ଯେ ଯଦି କିଛି additional step apart from 402 is taken, then 399 can be invoked. 402 ରେ mere assembly is sufficient. No preparation is required or sine qua non. But in case of 399, there has to be certain kind of preparations involved. Mere assembly is not punishable under section 399. Mere assembly is punishable under 402. Preparation is a mandatory or imperative ingredient under section 402. Now back to the concluding judgment in case of Chaturi Yadav and others versus State of Bihar, where the Supreme Court held that persons found assembled at a lonely place in the school premises were detected by the police patrol party, and on seeing the police party, some of the accused persons ran away, but some of the accused persons were caught. And from their possession, guns and live cartridges were found, and they were found guilty by the learned trial court under section 399 and 402 of IPC. And their conviction were confirmed by the High Court, but the special leave to appeal was allowed by the Honorable Supreme Court, and the judgment of the conviction was set aside, and the appellant were acquitted of all the charges. These are the factual background. Then the court is considered opinion that the contention raised by the learned counsel for the appellant, counsel is missing here, is well found and must prevail. The evidence led by the prosecution merely shows that the appellants are guilty under both the offences merely from the fact that they had assembled at a lonely place and could not give any explanation for their presence at that odd hour of the night. So just because the appellants had assembled, the last two lines are important here, just because the appellants had assembled for the purpose of committing a dacoity, or they had made any preparation for the committing the same. These two aspects were left untouched by the prosecution. No evidence was adduced. That is the reason why they were acquitted. So their presence at that odd hour of the night and in possession of certain articles would not throw or would not make them punishable under section 399. That's why they were acquitted. Because 399 ingredient ସବୁ satisfy ହବାର ଅଛି, ତାଙ୍କର ଗୋଟେ intention ରହିବାର ଅଛି ଯେ ଡାକଏଟି କରିବା ପାଇଁ, ତାଙ୍କ preparation ଟା ବି firmly establish ହବାର ଅଛି। କେମିତି ସବୁ establish ହବ? These are all the matter of facts. ଗୋଟେ example ଦଉଛି, ये cases ରେ normally police officer ନିଜେ ହିଁ witness, prosecution witness ଥାନ୍ତି। ଗୋଟେ କେସ୍ ରେ ଏମିତି ହେଇଥିଲା ଯେ ଯୋଉ ସବୁ prosecution witness ସବୁ ଆସିଥିଲେ police officer ନିଜେ, ସେମାନେ recover କଲା time ରେ ଗୋଟେ police officer ଗୋଟେ fact depose କରୁଛି, ଆଉ ଗୋଟେ police officer ଆଉ ଗୋଟେ fact depose କରୁଛି। normally ଏଇ ସବୁ ଜିନିଷ ଅନ୍ଧାରରେ ହେଇଥାଏ, ତ ସେଠି ସବୁ କୁହନ୍ତି ଯେ without any source of light how can we be so certain about the facts? So at many times it is very difficult to prove the case. So first there was a case where the police officers cannot establish or their statements made by one police officer is quite in contradiction with the statement made by another police officer. ସେଥିଲାଗି ଆଉ independent witness କେହି ନଥାନ୍ତି ଯଦି ବି କେହି independent witness ଥାନ୍ତି later they turn hostile or they don't depose accordingly as per the prosecution. So it is very difficult in the part of prosecution to prove the case under section 399 or section 402. ସେଥିଲାଗି our conviction rate ବି ବହୁତ କମ ଥାଏ. So these are the legal aspects we need to touch while answering this question.